To begin with, I would like to congratulate Chamber of Tax Consultants for completing 100 glorious years. 100 years, it's not just about the passage of time, it's about the trust that is created, the legacy that is built, and the impact that will go on for generations. Hi, I'm Meenakshi Pahuja from A&B Legal. I'm an integral part of the private client practice and dispute resolution team. Let's talk about probate. What is a probate? A probate, in simple terms, is a legal document proving the existence of a will. It is a document issued by the court certifying the authenticity and the enforceability of a will. In simple terms, the court certifies that the will is genuine. Now, if the will or the codicil is made within the jurisdiction of the High Courts of the presidency towns, that is Bombay, Madras, Calcutta, or if the property which is bequeathed under the will is situated within such jurisdiction, then probate is mandatory. For other states, obtaining probate is not mandatory, but it is always advised and encouraged that one must apply for probate. Why? Because it helps a lot when it comes to transmission of assets, because it will save you from the hardship of procuring and producing multiple documents. Now, who files for the probate? The executor mentioned under the will files for the probate. He will file a petition to the court while submitting the original death certificate and the will of the deceased. He will also submit the consent affidavit of the legal heirs and the affidavits of attesting witnesses. These are mandatory requirements, and in some cases, the death certificate of the legal heirs of the deceased may also be required. Now, once the probate petition is filed, the court verifies all the details and the documents submitted along with it. Then, the court issues notices to the concerned parties who would be most directly affected if the probate would be granted. Such notices are issued to invite objections and claims as regards to the grant of probate. If no objections are raised and if no claims are received, then the court grants probate. But what happens if there is no executor mentioned under the will? Can we not file for probate? Not probate, but we can apply for letters of administration with will. The effect of letters of administration with will or without will and probate would be the same. In case of letters of administration, an administrator would be appointed by the court to administer the estate of the deceased. The process usually takes around 6 to 8 months. Once the probate is granted, the executor has the legal authority to deal with the estate of the deceased. He is then obligated to distribute the estate of the deceased amongst the beneficiaries as mentioned under the will, and therefore the wishes of the deceased are being fulfilled. Now, we must have heard where there is a will, there is a way. From now on, we will remember if there is a will, it must be probated. We would love to know your thoughts on this video. And of course, if you have any questions, we would be very happy to answer them. Stay tuned for more such informational videos. Thank you and goodbye.